said to counsel, and welcome to Mr. Walsh. I have a few things on my agenda. The first one, which is over here, is the competency. I've now received a report from Bridgewater State Hospital, a comprehensive report from Dr. Ryan. And in that report, Dr. Ryan concludes that the defendant is competent and ready to stand trial. And with that finding, which I accept, I had a brief conversation with the side of the bench. What's the defense's position? I just want it on the record, on the public record, with regard to the defendant's competency.
Two things here. One, we're not contesting the competency findings. Two, we've had conferences with Dr. Ryan. We had one last month. What he asked us to do, is he is concerned that changing the environment to the jail may have an adverse effect on this report. He wants us to advise us, ask us to inform the court if he's concerned about that. He said that's not his lane, so to speak. But we do. We want to let the court know that we have those concerns, and we'll bring it to the court's attention as soon as we think they might be posing a problem. And we're also informing the jail that there is but other than that, we're not contesting competency.
All right. As with any case, and any time, in my experience, the defendant goes to Bridgewater and then is returned to the facility, there's always a transition period. He's been there for 40 days now and has gotten, as I understand, into a routine. And that routine is going to be changed as he moves back to the House of Correction. So understandably, there will be some transition period, and you and alerting the facility knows this, they deal with this quite regularly. But I understand your intent to alert me to it, and we'll have some time here, I believe, between the time that we're picking a jury in this case and the time. I'm not suggesting that you're not working at that time, but the defendant's role in that is significantly different than it is when we're actually actively engaged in the trial. So hopefully that'll give him a nice time to settle back into the House of Correction. But obviously, if at any point you become concerned about that, I know you won't hesitate to raise it with me.
Thank you.
All right. So, let me, and I discussed this with you at this side of the bench as well. I received some edits from the defense to the questionnaire, which I will incorporate into the next version of the draft questionnaire. It's always a draft until the minute that I finalize it and send it to that pool of jurors. Speaking of that pool of jurors, somewhere on my desk, I have the updated numbers. Who knows what the yield will be, but I expect to take about 70, if I can, 60 to 70 jurors a day. In my experience, it's hard with the questionnaire, even without doing all the copying, to get through more than that number in a day, and there are other cases that are starting on Tuesday. And so if we can accommodate those, we will. We'll have to see what the draw is. The expected number is 105 now for Monday, and we're going to hold those over to Tuesday because, as you know, we're doing the final trial conference on Monday, and then we'll start the empanelment on Tuesday. So it looks like 105, 126, 121, 68 on Thursday, but those people will be pushed and held over till Friday. So we'll have a full group of some number of people to work with in getting a jury next week. And then jurors are here also on Monday and Tuesday of the following week. And I think we're the only game in town. That is, I don't think anybody else is paneling on Monday and Tuesday. Our intent is, if we get a jury during that allotted time, we will start the trial, the substance of the trial, on 12/1, the Monday after the Thanksgiving holiday. Everybody on board with that schedule? All right, good. Let me next address, and then once I do this, I'll certainly turn it over to you. We're going to have our formal, really today's purpose was to address the competency. But to the extent that I could pick off issues that aren't technically motions in limine, but other important motions to the parties, I focused on those today. And I am prepared now to make a ruling on the change of venue paper. That's paper number 219, and I'm going to read that into the record now. Mr. Walsh has moved for a change of venue on the grounds of extensive and prejudicial pretrial publicity that he asserts has tainted the jury pool so as to deprive him of his right to a fair trial by impartial jury. Alternatively, the defendant seeks an order that prospective jurors be selected from outside of Norfolk County. In support of his motion, the defendant has submitted evidence of extensive national and local media coverage of the case, beginning on January 6, 2023, after Anna Walshe was reported missing, and continuing till the present day, as well as evidence of social media engagement with this case. After careful consideration of the defendant's motion and the exhibits provided to the court, I'm denying the motion and the request for alternate relief for the following reasons. The court may order a change of venue where there exists, quote, and it exists in the community where there is a prosecution is pending so great a prejudice against the defendant that he may not there obtain a fair and impartial trial. And that cites back to Massachusetts Rule of Criminal Procedure 37 and Commonwealth versus Clark, 432 Mass 1 at 6, a 2000 case. A judge has substantial discretion to transfer a case to another county based on pretrial publicity. And according to Commonwealth versus Gaynor, 443 Mass at 245 at 259, pretrial publicity, even even pervasive adverse publicity, does not inevitably lead to an unfair trial. A change in the place of a trial should be ordered with caution and only after the defendant has established, based on a, quote, solid foundation of fact, that the pretrial publicity has created presumptive prejudice. And to that I cite to Commonwealth versus Hart, 493 Mass 130 at 141, and Commonwealth versus Tulin, 460 Mass at 452, at pinpoint site 462, 463, a 2011 case. Presumptive prejudice exists only in truly extraordinary circumstances where the trial atmosphere is utterly corrupted by media coverage. And, quote, the entire venire may be presumed prejudiced, regardless of specific voir dire procedures utilized. This standard is only met if the publicity is both extensive and sensational. And to that I cite to Commonwealth versus Who's, 467 Mass 395, 406, a 2014 case. In assessing whether pretrial publicity precludes a fair trial, the court should consider additional factors such as, quote, the size of the community, the length of time between the peak media coverage and the date of the trial, and whether the news stories contained a confession or smoking gun rather than merely being unkind portrayals of the defendant, end quote. Commonwealth versus Garhut-Strider, 82 Mass Appellate Court 500, 506, a 2012 case. The defendant here contends that transfer of his case out of Norfolk County for trial is necessary because the nature and extent of the negative pretrial publicity his case has received has encouraged a bias and prejudice against him in this county. Having reviewed the numerous materials submitted in support of the defendant's motion, I conclude that presumptive prejudice has not been shown. Although the media coverage has been extensive and somewhat graphic due to the nature of the crimes charged, it has also been primarily factual, describing the events in question, the charges against the defendant, court proceedings in this case, and the defendant's criminal history. Quote, fact-based publicity, even that which contains references to charges pending against the defendant or a prior criminal record, is not the sort of sensational publicity that would give rise to a presumption of prejudice, end quote. And that's Who's at 467 Mass at 407. The publicity in this case peaked in January 2023 when the defendant was charged in connection with the victim's murder, and has decreased in frequency over time, undermining a presumption of prejudice. Again, Who's at 406 and Tulin at 460 Mass at 465. Notably, nothing in the defendant's submission addresses whether the pretrial publicity has been more extensive in Norfolk County or the likely number of potential jurors who were actually exposed to the media coverage. Moreover, other factors weigh against a finding of presumptive prejudice. The trial is scheduled to take place nearly 3 years after Anna Walshe was presumed dead, and therefore there has been a substantial amount of time between the initial media coverage and the selection of the jury. Indeed, much more of the recent media coverage is focused on court decisions leading up to trial and the status of the case. Further, the defendant has not shown that there has been any report of a confession by him or any like evidence. See Gerhardt's writer, 82 Mass App Court at 506. And unlike other cases where the small size of the community weighed in favor of a finding of presumptive prejudice, for example, in Nantucket County, given the size of Norfolk County, the defendant has not shown a high likelihood that the entire jury pool would be tainted by the pretrial coverage of this case. To that, the court cites to Commonwealth versus Leahy, 445 Mass, 41 at 493, 494, a 2005 case. Defendant's motion relies heavily on evidence of negative social media posts presuming his guilt. There is, however, no indication that any of the posts were made by or read by Norfolk County residents, and thus they do not present a compelling reason to transfer his case to another county. In sum, while the defendant has demonstrated that the national and local media have extensively covered his case, he has not demonstrated the, quote, type of emotionally charged, inflammatory, sensationalistic coverage needed to support a presumption of prejudice, end quote. United States versus Angulo, 897 F. 2nd, 1169, 1181, a First Circuit case from 1990. Nor has he shown that there exists in this community a prejudice so great that he cannot obtain a fair trial in Norfolk County. Thus, I will not now order a change of venue. Alternately, the defendant has requested that prospective jurors be seated from outside of Norfolk County and transported to Norfolk County Superior Court for trial. Quote, such an order ought not be given lightly. Commonwealth versus Aldopoulos at 390 Mass, 438, 448, 1983. The defendant must, quote unquote, fully establish the reason why a foreign jury is, quote, necessary to further the administration of justice. The defendant's motion falls short here. The defendant has not specified in his motion why he cannot obtain a fair trial with jurors from Norfolk County. He has not, for instance, shown that the media or social media coverage has been more widely viewed by prospective Norfolk County jurors as opposed to residents of other counties. That engagement with social media postings about his case has been higher by residents in this county, or particularized his evidentiary support to the residents of Norfolk County in any way. merely explaining the widespread coverage of this case in the greater Boston area and providing examples of negative social media posts from unknown users is insufficient to establish the necessity of a foreign jury. Any concerns as to the impartiality of prospective jurors from this county due to pretrial publicity will be addressed by this court with careful and thorough voir dire and is always subject to reconsideration by this court. Accordingly, the defendant's motion for a change of venue or alternate relief is denied without prejudice. The defendant may renew his motion, and the court won't hesitate to re-examine its own decision should the impanelment of an impartial jury prove impossible as a result of community prejudice. So there's one other matter that I want to address with the lawyers, and that will take place at the side of the bench. But before I do that, are there other matters that it's important for the parties to raise today, recognizing that we are going to have the final trial conference on Monday? Bless you.
One quick one, Your Honor, was I know that Mr. Tipton had a hearing on 12/9. I didn't know if the court was going to break for that at 2 o'clock.
Oh,
I was going to ask this side, I want to talk about that briefly.
all right. Anything else?
No, that's it.
All right. Anything from the defense other than what we're going to discuss at the side of the bench?
No, and